8. And just to make sure, I don't expect so, but do we have Ethan Hemphill?
No, I was told he didn't have to be notified of the hearing.
That's correct. You don't have to respond, ma'am. I'm just making sure that I call his name and inquire if he is here. So is there an Ethan Hemphill present? Okay. I will note for the file that Mr. Hemphill is not present. A previously ordered default was entered against him for failure to respond or appear. Ms. Humphrey has provided the court with her proposed final orders. I did also note the certificate of compliance from the courthouse facilitator. So, ma'am, I have reviewed your orders. I appreciate you working with the courthouse facilitator. Everything appears in order. I just had a couple quick questions for you, and then I will sign these and let you log off. I have signed the final order and findings for a parenting plan, residential schedule, and child support. I have also signed the parenting plan. One question I had, and I think this might just be a typo, on page 4 of the parenting plan, did you intend to remain sole decision-making for school and educational, or did you intend for that to be joint?
No, that's just sole for me. It was an accidental mark.
Okay, I'm just going to white out that accidental mark.
Okay.
And just initial that's what we are intending. Okay, so then with that question answered, I will sign the parenting plan. I have also signed the child support worksheet. The last question I had was just on the child support order. On page 10, under post-secondary educational support, you had marked denied. More typically, the court will reserve on that, especially with a young child, where if the child does attend post-secondary, a parent can come back and ask for support for post-secondary. Would you be asking the court to reserve on that issue for a later date, or do you want that denied outright?
No, you can go ahead and deny it outright. We have, through our family, we have a college fund and everything set up for her, so I'm not concerned about that in the future. Okay.
That was my last remaining question. Other than that, I have signed the orders. I will hand them to the clerk for filing. Do you have any questions for me?
I have a couple I'm not sure you can answer. I do know that now that these are signed and they go to the clerk, I have to serve them to Ethan. Is that correct?
That would probably not be in my purview. So I can't give legal advice. I would tell you procedurally, the motion for the order for default indicates that for this court to make decisions, he does not need to be served because he has failed to appear. My recommendation probably is that because the order does put specific obligations on him, it probably is in your best interest that he know about what the court has signed.
Okay, understood. And then again, it's another question I don't think you can answer, but because you're signing the child support order, and I don't have DCS involved, so I just make sure he's aware of that, and then if that doesn't work out, then I get DCS involved.
So you can, so I'll answer it from the purview I have. So if you want to talk to someone at Child Support Division about it, I would recommend you do that. From our perspective, if he fails to adhere to the child support obligations, you would be bringing a contempt motion back before this court.
Okay.
Okay. Anything else?
Nope, I believe that's it. Thank you very much.
Okay, you're free to log off. What I have received to just let all the parties know, Ms. Teft has filed additional contempt motions that are set now on future dockets. So I have received those. I think more importantly, what just came in that probably affects what we do today, and Ms. Morris Teft, let me know if you've received this. On October 6th, the court received Mr. Teft via his counsel, a motion to vacate order and stay order and contempt proceedings. Have you received that?
No.
Okay.
Yeah, again, he doesn't send me a copy. He doesn't serve me a copy or nothing. Michael seems to do what he wants.
Well, okay, so it's a little bit different here, ma'am. What I'm telling you is that so you'll recall, we had court appointed counsel because there was a potential jail sanction involved in Mr. Swenson now represents him. As part of that representation, he has filed a motion to vacate the underlying dissolution order and to stay the prior the contempt proceedings. That motion went in front of a judge ex parte to be set on our October 17th docket. And what the judge did sign was a statement that pursuant to Court Rule 62B, the judgments against the respondent and contempt proceedings are hereby stayed until further order of the court or a determination of respondent's motion to vacate the judgment, whichever comes first. And that was signed on October 9th by a Superior Court judge here in this county.
What does that mean?
What it means is we can't move forward with contempt proceedings today. We have to first have a hearing on whether this court is going to what's called vacate the dissolution order that was previously entered that did award you spousal support. But first, you need to get a copy of that motion in order. So I believe Mr. Swenson has noted that for this docket for next week, October 17th.
I believe it's the attorney docket, Your Honor.
Oh, yep. Thank you.
Should I get an attorney? Because I feel like I need to get an attorney then, because if he's trying to get rid of that, and can I get appointed attorney then too as well? Because I feel like that's not right for him to try to get rid of when I gave him opportunity to respond back to the dissolution of the marriage, and also respond back to all those other things like in the contempts. I've tried to work with him, and he chose to not to work with me and chose to just be stubborn and stuff. And I just feel like since he got an attorney now, the attorney's trying to get rid of it for him, and I don't feel that's right.
I understand, ma'am, and I'm not here to talk you out of that feeling. I understand your concern. I want to do things a little bit step by step. First, Mr. Swenson, I do note that is set for October 17th, 9 a.m. My guess is that may get continued if Ms. Morris Teft is going to be seeking counsel, but for current purposes, has that motion been served on her, or is that in the process?
I believe my legal assistant sent an email to the email that was in the pleadings for Ms. Morris Teft yesterday, and then we've sent it out for personal service as well.
Okay. So Ms. Morris Teft, I do understand your concerns. Let me ask you a couple questions. What is your current income?
Right now I'm not working because I'm in school for a phlebotomy school that I just started, and I graduate that on November 9th. And then after November 9th, I'll start working at the hospital.
Okay. And what type of school?
It's phlebotomy school in Clackamas, Oregon.
Okay. And then you said do you already have the job lined up at the hospital?
No, they help job placement after you graduate, and graduation is November 9th because it's a 6-week program.
Okay.
And class don't start until October 28th. Okay. But I just got enrolled in that. But before then, I was working at Level Wyoming and CAT in the housing department.
Okay. And when did you stop working there?
The end of last month.
Okay. And how much were you making at that time?
Minimum wage, and I was working 20 hours a week, and I was only for 3 months. I only worked there for 3 months because before then, they had gave Michael a job working at CAP, and he was working full time.
Okay. So I think what I'm going to do at this point, I mean, this is a very unusual situation. Mr. Taft was appointed counsel essentially related to the jail sanction. But I can see how the defense to the jail sanction is this motion to vacate. So I do think that is in the purview of court-appointed counsel. Ms. Morris-Taft, we don't typically appoint petitioners court-appointed counsel, but I understand your argument. So what I am going to...
Oh, sorry. I only say that because the past contempts, when Michael was working full time, he didn't pay nothing, and yet he's just like, it feels like he's just gets away with that and doesn't have to pay nothing.
Well, ma'am, what's been raised in the motion to vacate are some legal arguments about whether he was given certain rights that the court has to look at to respond, whether the order comports with the law. So there are legal arguments that have been raised by the motion that I think that you will want an attorney to respond to. What I am saying, though, is that typically on the family law docket, so Mr. Teff was appointed counsel because there was a jail sanction involved. We do not typically, at county cost, appoint attorneys for family law matters. So what I'm going to do right now is reserve on that issue. We'll set that issue over to the October 17th docket. What I would like to happen in the meantime is for you to receive and review the motion that's been filed. And then you can determine if, again, when you come back on October 17th, if you're going to be asking for us to make a ruling on whether we can even appoint you court-appointed counsel. But I would recommend that you seek either low or no cost counsel in the meantime on your own once you receive those documents. It sounds like they are in your email.
If I can't get low or no cost counsel, can I get the courts to pay for it like you guys did for Michael?
So again, if you're listening to what I'm saying, I'm telling you he was appointed counsel because jail was a sanction and we constitutionally have to give him that right. There's no constitutional right to an attorney for you as the petitioner asking for alimony. So I'm going to reserve on that. I'm asking you to do some legwork on your own to see if you on your own qualify for low or no cost legal counsel. And then okay. I will reserve on it. So I'm not denying your motion. We'll revisit that motion on October 17th when you're back in front of the court. If you've received the documents, you still believe you need an attorney and you haven't been able to get one for yourself, okay?
Okay.
Okay. So what that does to the contempt hearing today is I'm going to continue it in a stayed status. So we will be taking no action on the contempt motion at this time that was before the court today. Your next appearance, October 17th, which will be a Tuesday, Ms. Morris-Taft. It's a different docket. It's not the pro se unrepresented docket. It's now called the family law represented docket.
Okay.
Okay, so it's a little bit different. It's a Tuesday, but it is at 9 a.m.
Tuesday.
Mr. Swenson, anything else on behalf of your client today?
Not at this time, Your Honor.
Okay. All right. Ms. Taft, any questions for me?
No, you said Tuesday at 9 at October 17th, right?
Correct.
Okay.
And then check your email. It sounds like the documents are also being personally served on you. But if you'd like to start looking at those, I would recommend you check your email.
I will, and I'll give a couple of lawyers a call too as well that I have in mind.
Okay, sounds good. All right, thank you all. Mr. Taft, right. You're free to log off as well. And Ms. Burkett, I assume she's I don't know what her status is, but I don't see her here.
Your Honor, I can inform the court on that.
Okay.
I got an email last week from her mother, Sandy Burkett, and she indicated that Ms. Burkett's release date from jail will be on October 23rd. And Ms. Burkett is asking that this matter be set over until the second week of November.
Okay. Let's see. I'll come to you just a second, and Mr. Llewellyn. I'm just looking to see what would be our closest date to the 23rd. Was there any indication, Mr. Lawrence, why she was requesting that date versus kind of first available after release?
There was some mention about her wanting to file a motion, but I don't know what that motion is.
Okay. Thank you. I appreciate that. Mr. Llewellyn, let me hear from you. I know when you've been here in the past, we've talked about you filing your own motion regarding amending visitation. I haven't seen that come through. Let me know your position and what you're asking of the court.
So that was my fault. I tried to turn it in on Monday, but I realized that there has to be 3 days. I contacted the court, and that was my bad. So I'm still working on that. I got to get it turned in for next court date, I guess. I dropped the ball on that one, but I'm asking still for unsupervised visits, and if overnight stays are possible, that'd be really cool. We talked about it once in the past, like 4 or 5 court dates ago. I don't believe it was you though. I think it was a male. So yeah, I guess I'm just still asking for the same thing, and I dropped the ball. So I need to turn in the papers, and November, whenever that is, we'll talk about it again.
Okay. Well, here is my thought. So the last order we have on visitation is from June 8. And I know, so Mr. Llewellyn, why don't you tell me just a little bit today about, I know your prior concerns were regarding the supervisor being unavailable and that sort of thing. How has visitation been going since we were last in court August 23rd?
So Abel and I, on average, typically go a month without seeing each other. And when we do get to see each other, it's 4 hours, typically on a Sunday. We actually went 90 hours without visitation at one point, and we've gone a month and a half without visitation, getting 4 hours. Typically, it's about a month getting 4 hours, but whenever the supervisor is available, Abel is conveniently sick. It's come up a lot during my court date, or during my visitation times, that he's sick. And I really hope that's not the case, because I don't want my little guy to be sick. But other times she's just not available. She does bartending gigs, and she just doesn't seem to care about this that much. She bit off more than she could chew. She thought it was going to be like 10 hours a month. And she goes on like camping trips and dragon boat races and that kind of thing, and just says, sorry, not available. And then when we try to do a makeup time on my off weekend, Abel is out of town, even though we plan it like midweek or try to do the start of the week. It's just, it seems as though they don't want me to see him. And I get that, but I don't think it's right. And he doesn't get to see his mother, hasn't in a while, and rarely gets to see me. And as a 6-year-old, that's just, I mean, anyone can testify to the fact that that's difficult for a 6-year-old. And my mom sent an email to Mr. Lawrence, and she said that when Abel comes over, they told him that Tess is away on work and that she doesn't have access to a phone. But my mom stated in the email to Keith that when he comes over, he talks about jail, and we don't really know why that would be, but maybe he overheard a conversation or something. This is just from her email. I didn't know anything about it until I read the email. And as well as she speaks with Abel's teacher, because my mother herself is a first grade teacher, and she's friends with Abel's teacher. And his teacher said he clearly needs a parent in his life. He's just been different ever since Tess has been gone, and the fact that we rarely see each other doesn't help that case.
Mhm. And the supervisor is still Ms. Woodage, is that right?
Yes, Your Honor.
Okay. Mr. Lawrence, I guess I'm just kind of brainstorming. I will set a new, what I had us on for, but please correct me if I'm wrong, is a review of reunification counseling, how that's going, and whether one party is requesting unsupervised visits at this point. I think we talked a little bit about that at the last hearing. I have reviewed a new document that came in since our last hearing. So I'm hopeful the other parties have it too. It is the October 6th note from Barbara Brandhorst regarding reunification counseling, as well as her recommendation regarding unsupervised visits. Does that sound correct? Like, does everyone think that that's why we're here?
I thought we were here on a review of the guardian ad litem
That's what
appointing.
well,
Let's see what we've got there. So we did appoint a GAL on September 13. My notes are not showing a review of that, but Ms. Turnbull, tell me what your understanding is, and we can certainly address it.
Well, that was my understanding, is that this was just to review the compliance of the order, and I have been in touch with both parties. I've received some partial payment from Mr. Lakey. I have not received paperwork from Mr. Lakey. I have also been in touch with Ms. Jones. She has communicated she had an unexpected death in the family, and she would be delayed a little bit with her payment and her paperwork. So that is in progress. But I don't have paperwork and haven't moved forward, particularly with the investigation.
Okay. So, okay, that makes sense to me. I thought you were saying a review of whether you were going to be appointed as the GAL. So I wasn't sure if you were asking me that there was, or telling me there was a problem with the appointment. That's, I guess that's what caught me off guard, but I understand what you're saying now.
Okay.
So it sounds like to me, the two issues kind of go hand in hand, which is when I reviewed this case, I was looking at this from a perspective of, we have a reunification counselor who is recommending bi-weekly unsupervised visits in between reunification. But it sounds like Ms. Turnbull probably haven't been able to get to the point where you would have a position to give the court on that issue. Does that sound fair to say?
That's correct.
Okay. Mr. Lakey, why don't you, I have Ms. Jones has her hand up. Ma'am, go ahead, and then I'll go to Mr. Lakey.
I just wanted to let you know that my payment has been made in full, and Ms. Turnbull and I just exchanged emails this morning about my paperwork, which is complete.
I'm sorry if I overlooked that.
Well, it sounds like it just happened this morning. So
It did just this morning, yeah.
Perfect. Thank you for the update.
Yes.
Ms. Jones, have you seen that October 6th note from the counselor recommending unsupervised visits?
I have, yes.
Okay. What is your position on that?
First of all, I wish that those letters would come in adequate time for me to respond, because I would be able to put in a formal response with the court. My request at this time is that unsupervised visitation wait until the GAL has time for involvement.
Okay. So you are objecting to that at this point?
Yes, because really what my big objection is too, is what you're being presented is only Mr. Lakey's interpretation of what happened. That Ms. Brandhorst didn't ask for my interpretation. She didn't ask for my input at all.
Okay. Mr. Lakey, what is your request of the court today? And then I'll make a decision and we'll set a new date.
Well, it's kind of hard, Your Honor, to do the reunification counseling because of the situation of I need time, I guess, with Rosie to talk to her about things, you know, and get to know her again, so to speak, other than just reunification counseling, because we've kind of gone backwards since this has come up for unsupervised visits. We've kind of gone back like 3 months in our sessions and stuff. It was going really good until Miss Randhorst wanted to do, you know, suggested the unsupervised visits. Now it's gone the other way again.
And what's your perspective on why that's the case? Why do you feel that it's gone the other way?
Well, when we're there, Rosie will step out into the lobby where Mrs. Jones is, and then come back in and, you know, basically rehashing the past again.
Mm-hmm.
And we were past that to a degree, enough to, you know, go to unsupervised visits, is what Barbara had said.
Mm-hmm.
And now we're back to rehashing the past again.
Ms. Jones, go ahead.
I think that it's very unfair to put that blame on me, Your Honor. This has been the behavior the entire time of the reunification counseling because Rosie is very angry. And Rosie stepping out into the lobby to talk with me was actually Ms. Brandhorst's recommendation. And, you know, I would encourage Mr. Lakey to come out and follow her and hear what I am saying to her, which is please go back in, talk with Barbara about your feelings, let her help you express that to your dad. That is always my recommendation to Rosie when she checks in with me. And again, that is at Ms. Brandhorst's request that Rosie be able to do that.
Mm-hmm. Okay. And Ms. Jones, do you anticipate speaking to Ms. Brandhorst about your concerns over unsupervised visits?
Ms. Brandhorst has not asked for my input at all through this whole ordeal. She has met with me one time and has not requested any more meetings with me or has requested any information from me or a check-in or anything.
Okay. So here's what I'm going to do. I do think it is appropriate to give this time. We just appointed Ms. Turnbull to this case very recently. I think that given the objection by Ms. Jones but also taking into account, I do have a professional in the field recommending unsupervised visits in some form, at least bi-weekly, while reunification counseling is going. I have to balance those competing interests. I will give this a little more time. I'm not going to make changes to visitation today. I am going to wait for the GAL to be able to spend a little more time with you folks to make a recommendation to the court. How much time do you think we might need for that, Ms. Turnbull?
Well, it'd be very helpful if I had the paperwork back from both parties. I would think if we could do 30 days, if the parties could get their paperwork back to me within the week.
Yeah. Mr. Lakey, do you anticipate being able to get that paperwork back to the GAL quickly?
I'm working on it, Your Honor. I'm also working on my final part of my anger management classes as well.
Okay.
And so there's paperwork on that. There are papers that I got to do on that as well and stuff. And so it's kind of been hard juggling.
Understood. Understood. And when you do, so is the anger management course, you said almost done? Are you almost done with that?
Yes.
Okay.
I think it's either 3 or 4 weeks left.
Okay. That certificate of completion or note of completion, however they do it, would be helpful to get to Ms. Turnbull as well.
Mm-hmm.
Okay.
Okay.
So let's go ahead and set this out 30 days. Are the parties available November 8 at 9 a.m.?
Yes, I am.
Yes, Your Honor, I am as well.
Okay. I am as well.
Okay, so we'll go ahead and do that. We'll set this review out to November 8th. Is there anything else we need today? Any questions from the parties?
I just want to say that I have no problem. I thought when Rosie went out, that she was to go out. I wasn't to follow or anything. This was new to me today. And I'm trusting that everything's going right.
Yeah. Well,
But as far as knowing that I could go out there, I did not know about that or anything. And it's not something I would do. She's going out there for like a timeout.
So I would just recommend that you keep in touch, maybe address that with Ms. Brandhorst and ask her at your next appointment, what do you recommend I do when she leaves the room? So I would inquire, I mean, certainly that's way outside my purview or expertise, but based on the notes I'm receiving from Ms. Brandhorst, we are making progress. So I am happy to see that for the sake of both of you and your child. So keep doing what you're doing, everyone. I think you're making slow and steady progress for your child. Okay.
Okay.
All right. We'll see you back on November 8th. We have
All right.
been
Thank you.
here a few times on a motion in order for default. I know Ms. Steinweg has been taking great efforts to get a change to the parenting plan done. Adequate cause was granted previously. The next step was for Ms. Steinweg to have a hearing on her proposed parenting plan, given that a judicial officer did find adequate cause to modify or at least re-review the parenting plan. What happened from there appears to be that mediation was scheduled instead of a hearing. Mr. Olson did not show up for that mediation. A judge, hold on a second, I'm not done yet. A motion to show cause was set, but then converted to a trial assignment. When Ms. Steinweg went to get a trial date, the judge told her that it appeared Mr. Olson was in default status, and so they couldn't continue with the trial. And I'm just reciting this so that Ms. Steinweg knows I am very aware of all the steps she's taken to try and get where she needs to go. Mr. Olson, you recently, once the motion for default was brought, did appear. The court gave you a deadline initially to respond. You failed to respond by that date, but indicated some reasons for why and that you were going to get that done. I do see, so our last hearing was October 4th. I had set that date as the deadline for you to file a response to the modification to the parenting plan. When we were here, it was not in front of me because you had just filed it. It has been filed with the date of October 4th. So I know that you have filed a response on the deadline I set for you. My question is, did you serve that declaration on Ms. Steinweg? Has she had a chance to see what you sent the court?
Yes.
Okay.
Your
Ms.
Honor.
Steinweg, yeah, go ahead, Ms. Steinweg.
So he was supposed to email me it, and that never happened. So Sunday, I asked if I could pick up a copy. I did get a copy of 2 pieces of paper that were typed. However, when he texted me a picture of 2 different pieces of paper. So he said that he's confused and unsure what he actually turned in. So I don't know if what's in front of me is what he turned in or not.
Okay, let's see. So the document that you have, I'll just kind of read to you the first sentence I have, what he filed, and tell me if it's the same thing you have. So the document I have is, let's see, 1, 2, 3, 4, 5 paragraphs long. And it starts with, to begin with, I would like to thank the court for this opportunity to write this declaration.
Yeah, that's correct.
Okay, and then the very last sentence is, once again, I would like to let the court know my appreciation in this opportunity to submit this document.
Yes.
Okay.
That's what I have in front of me.
Okay. Okay. So Mr. Olson, go ahead, and then we're kind of going to work through what our next steps are here. Go ahead, sir.
About the mediator, when we were supposed to get with the mediator, the mediator was working with me on my rental, my rent. Since I had lost my job, we had a contract going with my my renters, and that mediator had to back out, and they were supposed to give us another mediator, and I don't know if Tiffany even knew this. So I did miss that one court date, thinking that we had to see the mediator before we went to court, and that wasn't the case. And so I wish I would have seen the mediator, not just for the help for both of us, but obviously for me, because I really have just like not knowing what I've been doing through this whole case. And I am sorry for wasting everybody's time. Every time I come to court, it seems like I've done something wrong again. Like I went from low self-esteem to no self-esteem. So I'm just as frustrated as Zach's mom in this matter. I just would like to move on.
Have you done the other things the court ordered, like the hair follicle test or UAs?
Okay. I have.
And I know, and hold on, sir, just a second, because I know, let me just say this comes from a place of, I don't want to hear excuses. I just want you to tell me, because you've told me your excuses before and why you don't think that you need to do it. So I really just need you to answer the question right now, which is, have you done the drug testing that the court previously ordered?
No. And would you why?
I've heard your reasons before. Last time, I assume it's the same. Last time you told me it doesn't matter because you're admitting that you were using and that you had relapsed. So yes, it would have been positive. Is that essentially?
Well, no, I've tried to get one, but you have to have, it's $350. And I've talked to the secretaries here on information. They need a GAL or a attorney to an address to send it to. I even went to the legal advice place to talk to them about how I could get the hair follicle paid for and up front, but they need the money up front. I can't just go get a hair follicle taken.
Okay. So you don't have the money to pay for the hair follicle testing?
No, Your Honor, I am so financially hurting right now that I'm struggling to keep my apartment right now.
Ms. Steinweg, do you want to say anything to that?
It's just interesting to me that he has boats and all these things outside of his home, kayaks and things like that. And honestly, if you wanted to put your child first, you would get rid of those things to do this. I mean, I just don't feel like it's his priority right now.
Well, and at this point, the court order is essentially, visitation is contingent on you getting those things done. So I do think that should be very high priority for you, sir. Ms. Steinweg, what I'm going to ask you, did you have to pay for the mediation that he didn't show up for?
I paid the first time I paid, and then they sent me a letter saying that he didn't do it in time. The second time I paid, and he was able to, they called him on that day to try to get a hold of him to see why he didn't want to do it. He didn't answer the phone. They gave him 20 additional minutes. I did pay again. However, they reimbursed me my money.
They did reimburse you
Yeah.
was that for the June mediation that he didn't show up for? They reimbursed you for that?
There was that one, and then there was one before that we were supposed to do, and he didn't follow through with that either.
Okay. Well, let me ask you this. He is here now. He's responding. I think the prior judicial officer, why he sent you to mediation is he said it would be cheaper than getting a GAL involved, which is true. So I guess the question for you, Ms. Steinweg, that I would have is to proceed forward with getting your parenting plan changed. We can do a couple things, and I'm going to leave it in your court to tell me how you want to proceed because it's your motion. We could certainly get you back on a trial assignment docket to actually have a 1 to 2 hour hearing on the parenting plan that you're proposing. Now that he has responded, he wouldn't be considered in default, so we could get that set for you. You probably would want a GAL to testify in that type of situation. Or we could do a final mediation set. And I think at this point, I'd put the cost of that on Mr. Olson. So do you want to give mediation one more shot before we move forward with trial, or what is your request today?
I just don't feel that we're going to come to an agreement at mediation.
Okay.
And if he already hasn't followed through 2 times, I just don't understand why we're giving him so many opportunities. I mean,
Well, we're giving him opportunities because he's not considered in default by appearing after you filed your motion for default. He did appear. He has now filed a response. The law favors a resolution on the merits, not a default. So that's why. Those are all of the reasons that if I were to enter a default and just give you what you want today, it would get reversed on an appeal. So that's why we're doing the things now so that this doesn't drag on for 6 more months. So
Okay.
if you're saying you don't want to do mediation, I am fine. I understand your reasoning. I understand you all have tried this twice before. I understand that it is unlikely, especially with Mr. Olson not adhering to court orders. I can understand your position for thinking it wouldn't get you anywhere. So we could get you set for a contested hearing on the underlying parenting plan. I do believe you would want me to appoint a GAL that meets with the 2 of you and makes a recommendation to the court one way or the other about what the parenting plan should look like. If I do that, I'm going to inquire about each of your finances to determine if it's going to be at county pay or private pay.
is he able to pay for a mediator? I mean, I can pay my own portion. That's not the problem. The problem is trying to come to an agreement.
Right. And I understand. I hear you loud and clear. Yeah.
And I don't understand why he's even fighting this, considering I'm already getting him at least 1 additional weekend a month to get him to his activities and things like that. I just don't understand why.
And I can't answer that for you. All I can say is I understand your frustrations, and what I can do is ask you which venue you would like this to move forward with. We can move you on to a contested hearing. Let's
do the mediator and try to do that one more time. And then I guess we'll just move on from there.
Okay.
So
Mr.
is there a specific mediator that we cannot use? There shouldn't be a conflict of interest as they're just trying to resolve issues, correct?
Yeah, well, and that's news to me. I don't see anywhere in the documents that a mediator has said they had to recuse because of a conflict. The June mediator just simply said Mr. Olson did not show up. So that's at the Community Mediation Center in Longview.
And there's multiple when you go on the video chat.
I would be sending you back to mediation at that same place. Mr. Olson, let me ask you, are you open to mediation? Will you meaningfully participate in mediation?
Yes.
Okay. I'm going to do 2 things. I will send you all back to mediation. Mr. Olson, are you able to pay half of the mediation cost?
Well, the last time I got a discounted fee for being unemployed. And I was able to pay that, and I did pay that. And I also got refunded that too.
Okay.
But yes, I am.
Okay. So I'll go ahead and put the 50-50, and then sir, if you need to work with them on a request for a reduced rate, please do so. Let me make sure I have has either of your addresses or phone numbers changed since the last time you went through mediation?
Mine does not.
Okay. So Mr. Olson still,
his phone number has changed, or he sent me a different phone number. So
yeah, I was about to say, Mr. Olson, I don't even have a phone number for you right now. What is your phone number?
Well, I still am using the 232.
While he's doing that, what I'm also going to do is set what's called a show cause hearing on your parenting plan request just back in front of me on a docket, so that if mediation is not successful, we will move forward on that date without you having to go to a separate trial assignment docket.
So if we do not come to an agreement at the show cause hearing, will anything happen or we'll schedule a new trial date?
What'll happen is if you all go to mediation, if that is not successful, then it's going to come back to me. We'll have a show cause hearing on your request to change the parenting plan in front of me on this docket. So
Okay.
you're not going to be asked to, you do not think last time that's how it was going to go, but then and again, through no fault of your own, it's difficult when you're not represented. You did file a trial assignment request. I'm not going to have you do that this time. I'm going to keep the show cause hearing for your underlying request to change the parenting plan on this docket. So we'll set a date for that today.
Okay.
Once again, Tiffany has the phone number on her phone for this new phone number. I'm not sure how to get in there and find out the phone number of this phone.
Are you ready?
I am, yes.
It's 36.
Thank you.
Okay, I've got that on the order. On the last page, it asks if you are in agreement with the order I am signing, transferring this case back to mediation. Mr. Olson, for you, are you in agreement?
Yeah, well, I missed what you guys were talking about.
Okay, I'll come back to it. Just hold on. I'm asking, are you in agreement that I signed this order sending your case back to mediation?
Yes.
Okay, and then Ms. Steinweg, are you in agreement?
Yes.
So I'm going to indicate your agreement via Zoom. Mr. Olson, you had a question for me. Go ahead.
Yeah, on getting a hold of the mediator and what will they be getting a hold of me? Am I supposed to get a hold of them? Do you have a phone number I need to get? Because I know it doesn't look like I've participated and whatnot, but believe me, I don't know. What do we need to do to get a hold of the mediator? What do I need?
So I can send all that information to him.
Yeah. So I guess, Mr. Olson, I'm a little confused because you told me you've been in touch with them before and you've used them before. So,
yeah, well, you guys don't have any recollection of them saying that I needed to get a different mediator, that that there was a conflict of interest. And now I don't know what to say to that. Like, how come nobody knew about?
So let me just ask you a question, Mr. Olson.
Yes.
Does that have any bearing, that issue that you're raising right now that you seem so upset about, does that have any bearing on whether this court should change your parenting plan?
Well, no, but it's
okay. So we're going to move on. So what I'm telling you is you are being referred back to the Community Mediation Center. The phone number is 360-232-8622. They will receive a copy of this order. The order has both of your phone numbers on it. They will reach out to you. You are free to reach out to them if you would like. Okay. The last thing we're going to do is set a show cause hearing date if mediation is not successful. This is the date by which both of you will be asked to present your evidence as to why a parenting plan should be changed or should not be changed. Let's see. I don't know do you all recall about how far out they were booking the last time you did this?
It was about 2 weeks, I think.
Yeah,
they were pretty quick, actually.
I was going to say 2 or 3 weeks. So let's set you out just 30 days to November 8. If you're both available, November 8 at 9 a.m.
Yep.
That'll be our show cause date for the change to the parenting plan. Essentially, Mr. Olson, a contested hearing where you would be bringing forth testimony and evidence as to why you don't think the parenting plan should change, or if it should change, what changes you're proposing. If mediation is successful, we will strike the November 8th date, or at least we'll strike the November 8th show cause. We'll keep the date to review the mediation results, though.
Okay.
Okay. Any questions for me?
Nope.
Mr. Olson, any questions for me?
Yeah, on the hair follicle, where do we stand on that now? I'm
What do you mean? Where do we stand on that? You and I have talked about it every time you've been here. And I've told you there's a standing order from a different judicial officer that I am not changing. So it remains an obligation of yours to complete. And I would say this, the allegations of drug use were a significant part of the reason that the judicial officer found there was adequate cause to review the parenting plan. So yes, that still is a standing order.
okay, because I was down there yesterday, yeah, trying to get one, and I don't have $350. I also need an address for them to send it to. If I have a miracle, and someone, or I get help paying for it, I need to give them an address to send it to.
They routinely file those with the court.
Okay. Oh, what place are you talking about? And who are they? Because the place that I went to, they don't know.
I'm not sure what you're asking me, sir.
But when the court sends somebody to get a hair follicle, where do they send them? Because the secretaries out here on the second floor, they don't know.
I believe
The judge told you where to
Yep,
go.
I was going to say, I'm just looking at the notes from the hearing. I'm just going to go back there. I think the judge specifically addressed it. Yes, you asked this question, sir, on July 5th of 2023. Okay. So you were in front of the court, and I'll give you the exact time. You were in front of the court at 10:25 a.m. on July 5th, 2023, in front of an elected Superior Court judge in this county, Judge Scudder. And you asked at 10:31 a.m. where you needed to go. And at 10:38 a.m., the court responded, Mr. Olson, to obtain hair follicle test at Performance Occupational in Longview, no later than Friday of this week, and provide result to court.
Okay, their address is changed. Perfect. That's the place I went to.
Any other questions for me?
No, Your Honor.
Okay. Ms. Steinweg, any other questions?
No, thank you.
Okay, thank you both. You're free to log out.